Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations. Be ready for the high speed passage for JW exam. Start. Learned counsel for the opposite party number 2 has further submitted that admittedly the revisionist has not produced the high school certificate as required by Rule 12. Stop. The document on which the revisionist is relying is a photostat copy of the high school mark sheet in which the date of birth is of the revisionist is mentioned. Stop. However, it is not disputed that the original mark sheet was also filed by the revisionist at the appellate stage. Stop. The submission on behalf of the opposite party number 2 is that the high school mark sheet cannot be equated with matriculation certificate. Stop. When Rule 12 requires that there should be matriculation certificate, then any other document cannot be substituted in its place. Stop. The mark sheet is a document which states the marks obtained by a candidate in different subjects. Stop. It is not a certificate certifying any fact. Stop. According to him, in the absence of a high school certificate, the board and the first appellate court rightly relied upon the date of birth certificate issued from the school first attended, in which the date of birth of the revisionist is mentioned as 14/3/1987. Stop. The occurrence is of the date 2/5/2005, and as such the revisionist was above 18 years of age at the time of occurrence, and both the courts below have therefore rightly declined him to declare as a juvenile. Stop. It has also been submitted on behalf of the opposite party number 2 that the subsequent criminal case in which the revisionist was declared a juvenile and the order became final was in fact a manipulated case. Stop. The FIR of that case was knowingly got lodged against the revisionist, in which revisionist made appearance, and on his application the board declared him juvenile. Stop. Since the case was manipulated, one, therefore, the complainant did not file any appeal against the order declaring him juvenile, and the order became final, but the said order will not help the revisionist in the present case, because the board, under the directions of the appellate court, conducted inquiry and recorded a finding that the revisionist was not juvenile. Stop stanza. Learned counsel for the opposite party number 2 submits that this matter relates to a case in which a minor girl, while returning home with her younger brother, was forcibly picked up by the revisionist and other co-accused persons and was subjected to brutal gang rape by 6 persons. Stop. The accused persons not only subjected her to cruelty and brutality, but also her body was burnt with cigarette and lighter. Stop. After the aforesaid assault, the girl was thrown on the road. Stop. The complainant lodged the report of this occurrence with police station Ashiana, and the police, after a detailed investigation, submitted charge sheet against 6 persons, including the revisionist. Stop. The co-accused have already been convicted after full trial and have been sentenced to undergo 10 years rigorous imprisonment. Stop. One accused was sentenced to life imprisonment. Stop. However, two of them were declared juvenile, but they have also been convicted as provided under the Juvenile Justice Act. Stop stanza. It has also been submitted that the father of the revisionist is an influential person, and he managed to get an FIR registered as crime number 260 of 2005. Stop. The complainant of this case is no other than the real brother of the one of the accused in this case. Stop. This itself shows that it was done in a pre-planned manner so that the benefit of juvenility may be taken. In this case also, stop. The transfer certificate issued by Chhaya Public School, Bangla Bazaar, Lucknow, in respect of the revisionist showing passing of class 8 examination was absolutely a forged document, and on the basis of the said transfer certificate the revisionist took admission in Herald Public College. Stop. This witness summoned from Sherwood School has clearly stated on oath before the court that the said transfer certificate was not issued from his school. Stop. The submission of the learned counsel is that when the source on the basis of which the date of birth was mentioned in the Herald Public School was a forged document, the date of birth mentioned in the high school marksheet cannot be deemed to be correct. Date of birth. Stop stanza. Learned counsel for the respondents contended that the petitioners have been appointed against non-existent posts in the pay scale of rupees 4,000 to 6,000, about which an inquiry has been set up and the state government is still in the process of examining the same. Stop. In such a situation, the grant of higher pay scale of rupees 4,500 to 7,000 is erroneous, as the very appointment of the petitioner is in jeopardy. Stop. Learned counsel for the respondents further contends that the posts which had been advertised had to be first filled up by way of promotion under the rules and could not have been filled up by way of direct recruitment. Stop. It is for this that the inquiry has been set up by the state government to find out as to how this advertisement was tailored in a way to offer the post of direct recruitment in the pay scale of rupees 4,000 to rupees 6,000, and therefore if the petitioners have been given the benefit of a deliberate attempt to fill up the post through an incorrect advertisement, they should not be paid their salary in the higher pay scale, and as a matter of fact their appointments are also against the rules. Stop stanza. When the matter was heard on the previous occasion, and as the aforesaid picture emerged after the exchange of affidavits, it was further pointed out through the pleadings that all candidates who were entitled for promotion have already been extended such benefit, and the request for promotion by such candidates has already been granted. Stop. Hence, there is no occasion to cancel the appointments of the petitioners on any such ground, as the candidates have already been accommodated and have been granted the said pay scale. Stop. An argument was advanced on behalf of the state to protect the interest of the promotees, contending that if the promotions have been made, then the petitioners who could not have been appointed without the promotion having been finalized cannot claim seniority over them. Stop. Thus, the claim of seniority of the promotees was to be protected. Stop. According to the respondents, for Shri Ashok Khare, learned senior counsel for the petitioners, made a statement and has also filed an affidavit that the petitioners are not claiming seniority over the promotees who are entitled to be promoted, and they are prepared to forego their seniority to that extent. Stop stanza. After having heard learned counsel for the parties, it remains undisputed that the posts against which the petitioners claim appointment are posts which had been advertised depicting a wrong pay scale. Stop. The question as to whether the pay scale was deliberately indicated in the advertisement or not is a subject matter of inquiry by the state government, and the said inquiry therefore cannot be preempted by this court at this stage. Stop. However, the fact remains that the process which has been followed is that of direct recruitment. Stop. There is no dispute between the parties that the qualification and eligibility of the post in question are fulfilled by the petitioners and they were eligible for being considered to be appointed against the post of stenographers. Stop.